Good afternoon. My name is Samuel Ogojing, and welcome to this presentation. In this presentation, I'll examine the dispute between Aramika and Botuna regarding the suspension of a bilateral dam treaty, highlighting the complexities of modern treaty law, particularly regarding environmental obligations and evolving international norms. Aramika cites a material breach of safeguards, asserting its right to suspend the treaty. In contrast, Botuna invokes the doctrines of rebus sic stantibus and jus cogens, arguing that climate change and the newly recognized right to water have transformed the legal landscape. Moving on to the legal framework at the heart of this dispute, the cornerstone of treaty law, Pacta Sunt Servanda, is enshrined in Article 26 of the VCLT, stating that every treaty in force is binding upon the parties to it and must be performed by them in good faith. This principle underpins the stability and predictability of international relations, ensuring that states can rely on their agreements being honored. However, this obligation is not absolute. Is subject to exceptions provided for in the VCLT itself, such as material breach, supervening impossibility, and conflict with jus cogens. Article 60 of the VCLT provides that a material breach of a bilateral treaty by one party entitles the other to invoke the breach as a ground for suspending or terminating the treaty. A material breach is defined as a repudiation of the treaty not sanctioned by the convention or the violation of a provision essential to the accomplishment of the object or purpose of the treaty. The breach must be fundamental, not merely technical or minor in nature. This mechanism is designed to protect the integrity of treaties while recognizing that serious violation may justify suspension or termination. The doctrine of rebus sic stantibus allows for the termination or suspension of a treaty if there has been a fundamental change of circumstances since the treaty was concluded. This doctrine, though codified in Article 62 of the VCLT, has been discussed extensively in legal scholarship, including its application in historic cases like the 1870 Russian withdrawal from the Black Sea cause. Besides that, Article 62 of the VCLT sets a high threshold. The change must be unforeseen, must have constituted an essential basis of the parties' consent to be bound, and must radically transform the extent of obligations still to be performed. This doctrine balances the need for treaty stability with the reality that circumstances can change in ways that render original obligations unreasonable or impossible. Jus cogens norms are premonitory principles of international law from which no derogation is permitted. Article 52 of the VCLT states that any treaty conflicting with a jus cogens norm is void. Article 64 provides that if a new jus cogens norm emerges, any existing treaty in conflict with that norm becomes void and terminates. For a norm to attain jus cogens status, it must be accepted and recognized by the International Committee of States as a whole as a norm from which no derogation is permitted. Now, moving on to the discussion of issues. The first issue is whether Aramika's unilateral suspension is justified under Article 60 of the VCLT. The ICJ provided authoritative guidance in the Hungary-Slovakia case, which involved a similar dispute over a joint dam project. Hungary suspended and terminated the treaty, alleging environmental risks and breaches by Slovakia. The ICJ held that a material breach requires a violation of a provision essential to the treaty's object and purpose. In that case, the court found that while environmental protection was important, Hungary had not demonstrated that Slovakia's action amounted to a material breach justifying suspension or termination. Applying this reasoning, Armika must demonstrate that Botuna's failure to implement environmental safeguard was not only a breach, but also a breach of provisions central to the treaty's purpose, such as the prevention of ecological harm or the protection of downstream communities. If Botuna's conduct resulted in significant, persistent, and irreparable environmental damage, America's suspension could be justified. However, if the breach was minor, remediable, or not essential to the treaty's object, America's action may be disproportionate and contrary to the principle of Pacta Sunt Servanda. The Hungary-Slovakia case also highlights the importance of proportionality and the duty to renegotiate in good faith before resorting to suspension or termination. The ICJ emphasized that parties must seek to resolve dispute through negotiation and cooperation, especially where environmental risks are involved. Botuna invokes the doctrine of rebus sic stantibus, arguing that climate change constitutes a fundamental and unforeseen change of circumstances. The ICJ in the fisheries jurisdiction case and again in Hungary and Slovakia case set a high bar for invoking this doctrine. In the fisheries jurisdiction case, Iceland argued that changes in fish stocks and environmental conditions justify unilateral extension of its fishing limits. The ICJ rejected this, holding that the changes were not sufficiently fundamental or unforeseen to justify termination of treaty obligations. In Hungary, Slovakia, Hungary argued that new scientific understandings of environmental risks and evolving standards justify termination. The ICJ acknowledged the growing importance of environmental protection, but found that the changes cited by Hungary were not so radical or unforeseen as to meet the requirements of Article 62. The court stressed that the doctrine is to be applied restrictively to avoid undermining treaty stability. For Botuna to succeed, it must demonstrate that climate change impacts were truly unforeseeable at the time of treaty conclusion, and that these impacts have radically transformed the obligations under the treaty, rendering the original environmental safeguards absolute or ineffective. Comparative analysis in developing countries suggests courts are increasingly open to using rebel sink standards in environmental contexts. Given the increasing awareness of climate change over the past decades, and the likelihood that the treaty included mechanisms for review or adaptation, it is unlikely that Botuna could meet this high threshold. Furthermore, Botuna can also claim that a UN General Assembly resolution recognizing access to clean water as a jus cogens norms renders the treaty water division provisions void. Article 53 and 64 of the VCLT provide that treaties conflicting with jus cogens are void, and that the emergence of new jus cogens norms invalidates conflicting treaties. The ILC's work emphasizes that invoking jus cogens against existing treaty obligations requires clear evidence of universal acceptance. However, the elevation of a right to water to jus cogens status is a matter of considerable debate. The ICJ in North Sea continental shelf clarified that for a norm to become customary international law, there must be widespread and consistent step practice and opinion juris. For jus cogens status, the threshold is even higher. The norm must be accepted and recognized by the International Committee of States as a whole as non-derogable. Furthermore, the ICJ in Hungary-Slovakia case recognized the importance of environmental protection and sustainable development as involving principles of international law, but did not elevate them to jus cogens. Similarly, in jurisdictional immunities of the state and Al-Asani and United Kingdom, international courts have acknowledged the limits of jus cogens, ruling that even if a parliamentary norm is engaged, it does not automatically override procedural or jurisdictional rules unless specifically accepted by the international legal order. These cases underscore the restrictive and carefully defined nature of jus cogens and highlight the need for universal consensus before asserting the primacy of a parliamentary norm over existing treaty obligations. In addition, the articles on responsibility of state for internationally wrongful acts, particularly Article 26, reinforce the legal consequences of violating parliamentary norms by affirming that such breaches trigger heightened responsibility and may not be excused by domestic law or treaty provisions. However, the application presumes that the norm has in fact attained jus cogens status, which, as noted above, remains debatable in the context of environmental and water rights. Moving on to recommendations, Aramika and Botuna should prioritize renegotiating the treaty to address new environmental realities and integrate adaptive management mechanisms. Scholars have suggested that Rebel 6 statibus may serve as a stabilizing legal doctrine to renegotiate climate-sensitive agreements rather than disrupt them. This approach is consistent with the duty to cooperate and the principle of sustainable development as recognized in Hungary-Slovakia 1997 and reflected in modern multilateral environmental agreements such as the Paris Agreement. A revised treaty could incorporate flexible mechanisms for review, amendment, and dispute resolution that account for the impacts of climate change and evolving international obligations. If negotiation fails, the parties should consider submitting the dispute to arbitration or the ICJ as provided for in Article 33 of the UN Charter. following the principle of peaceful settlements of disputes. This also reflects the general obligation under Article 2 Sub 3 of the UN Charter, which mandates that all members settle international disputes by peaceful means in such a manner that international peace and security are not endangered. Resorting to suspension or termination under the VCLT should be regarded as a measure of last resort, only after exhausting diplomatic and judicial remedies in good faith. In the longer term, Botuna and like-minded states should pursue greater international consensus on the recognition of the right to water and environmental protection as a jus cogens principle. This will involve sustained advocacy through international forums, the development of consistent state practice, and the building of opinion juries. Future treaties, particularly those involving shared resources or transboundary environmental impacts, should include explicit references to evolving customary or pre-mandatory norms, with built-in review and amendment procedures to ensure resilience and flexibilities. In summary, Aramika's suspension of the treaty is legally tenable only if Botuna's breach is material and central to the treaty's object and purpose, as required by Article 60 of the VCLT and illustrated in Hungary's Slovakia case. Botuna's defenses under Rebel 6 Stendibus and jus cogens face significant challenges. Climate change, while serious, may not satisfy the strict criteria for a fundamental unforeseen change in the water right, though recognized as a human right, has yet to attain jus cogens status. Legal scholarship continues to debate whether environmental and water rights have reached the level of jus cogens, with many concluding the threshold remains unmet. The interplay of Pacta sunt servanda, material breach, and jus cogens reflects both the stability and adaptability of international law. Ultimately, the best path lies in negotiation, cooperation, and the gradual development of international norms, keeping treaty law responsive to environmental change and human rights while preserving the predictability vital to the legal order. And that's all from me. And this will be my references and bibliography. Thank you.